Good afternoon, Professor. How are you doing? Thank you for being here today. Today we are going to explore legal critical questions regarding privacy, search and seizure laws, and also digital forensic investigations across different jurisdictions. So my discussion will focus on more on key legal cases, principles, and international agreements that not only governs how evidence is obtained but also what expectations of privacy exist and when law enforcement needs a search warrant. So this topic is very crucial because it affects our rights as a citizen and the boundaries of law enforcement powers. So let's start with the first slide. So Professor, in the first slide of my assignment, this slide is all about the rules currently going in the states. So in the states, the exclusionary rule governs the admissibility of evidence obtained through illegal searches and seizures. This rule was established in the weeks we United States. I guess it's in 1914, 10 decades ago, and was later incorporated against the states in Map v. Ohio in 1961. The Supreme Court held that the evidence obtained in violation of the Fourth Amendment, which is also known as which protects against unreasonable searches and seizures. It is generally inadmissible in criminal prosecutions. I like it also known as U.S. Const Amend Fourth. However, we'll discuss the some of the exceptions to these rules in the next slide. So moving to the next slide. So what are the exceptions in the exclusionary rule? So I have mentioned three. So the first one is good faith exception. The second one is inevitable discovery doctrine. The third one is independent source doctrine. So what is good faith exception? So if a law enforcement officer offers rely on a detective search warrant in a good faith, so the evidence may still be admissible. Second one is inevitable discovery doctrine. So it like the sorry the good faith exception was published in 1984 and it was published by United States William. The inevitable discovery doctrine was published in 1984 in the same year, and it is published by Nix V. Williams. So, what is inevitable discovery doctrine? So, evidence obtained unlawfully may still be admissible if it would have been discovered legally through lawful means. Like the evidence obtained as a like it won't be admissible if it is not discovered properly or through legal actions. The third one is independent source doctrine. So it was published in 1988. It was published in Murray v. United States. So if a law enforcement obtains evidence from a separate or maybe we can say independent source, it is it is still unrelated to the illegal search, but it remains admissible. Moving to this slide. This slide is about evidence in like evidence admissibility in Canada. So in Canada, Section 8 of the Canadian Charter of Rights and Freedoms, it guarantees protection against unreasonable search and seizure. It's Constitution Act published in 1982. So if evidence is obtained in a violation of Section 8, it may be excluded under Section 24 second of the Charter, which means like the states that courts must exclude evidence if its admission would bring the administration of justice into the disrepute. So there are some key exceptions to apply in that, like I mentioned in the next slide. So explain the next slide. So moving to the next slide. So what are the exceptions to evidence exclusion in Canada? So the first one is good faith exception. Like it's published in 2009, SSC 32 by RV Grant. Like the evidence may be still admitted if law enforcement acted in a good faith, by means that there is by mistakenly it believed that their actions were legal. So second one is discoverability of the principle. If the principle would have been discovered through lawful actions, it still considered be admissible. And it's published in 2009 by R.V. Harrison. Yeah, and the third one is urgency and public safety. So the thing I mentioned, that evidence may not be excluded, but also it's obtained during urgent circumstances that directly prevent harm or save lives. Moving to the second question, what are the reasonable expectation of privacy in Canada? So there are three. So what is the reasonable exception? So the reasonable exception of privacy is a fundamental concept in Canadian law. It is protected under Section 8 of the Charter, which also guarantees that the right to be free from unreasonable search and seizure. Like this concept is particularly relevant in the context of computer systems and data, where courts have recognized that individuals have a significant privacy interest in the digital information. In the workplace, employees generally have a limited expectation of privacy, where especially when using employer provided devices or systems. So in like we as we discussed in workplace privacy, in the Supreme Court of Canada ruled that an employee had an reasonable expectation of privacy in their work or computers. This but this expectation was diminished when employers have monitoring uh, policies in place allowing for monitoring. The court emphasized that employees must balance their need to monitor employees and with the employees' privacy rights. So at home, also like in at home privacy, individuals enjoy stronger privacy protections. Like if it can be limited if they share devices or with networks with others. For example, for instance, like the in RV Morley, it's published in 2010. The Supreme Court found that the accused had a reasonable expectation of privacy in his home computer, but even though it is contained illegal material, the court also ruled that the police needed a warrant to search a computer as the accused's privacy rights. So it outweighed the state's interest in investigating the crime. The reasonable expectation of privacy test is also applied in the digital data, like the data stored in the cloud on a third-party servers. Like in R.E. Spencer, in 2014, it was established that individuals have a reasonable expectations of privacy in their network server or a network subscriber information, even though it is held by a third party. So the court ruled that the police must obtain a legal warrant and seizure to access those information, as it can reveal many personal and intimate information or details about an individual's online activities and surfing data. So, in conclusion, to wrap up quickly, the reasonable expectations of privacy in Canada, I think it is a dynamic concept that depends on the main context. While employees have the limited party or limited privacy rights in the workplace, but individuals enjoy stronger workplace, like stronger protections at home and even in the digital communications. So moving to the third question, does the concept of a reasonable expectation of privacy with respect to searches conducted by police existed in the EU, known as European Union? Does it still exist in the USA? So like the it like so the reasonable expectation of privacy in the EU is primarily derived from the Article 8 of ECHR, known as European Convention on Human Rights, which protects individuals from arbitrary or unlawful interference with their private and family life, also with home and correspondence. The right has interpreted extensively by the EU, like the European Court of Human Rights, also known as ACA ECTHR, which has established that government surveillance, police searches, and data collection must meet the requirements of legality, necessity, and proportionality. So there are some several key case law which I've discussed in the next slide. So moving to the next slide. So what are the key case law in EU? So I mentioned two. The first one is Benedict v Slovenia. It is published in 2018. So the ECTHR, also known as the European Court of Human Rights, ruled that accessing a user's IP address without a judicial authorization, it violates Article 8 of ECHR. The court also emphasized that the digital privacy is as much as important as privacy security. So, obtaining a minimal digital identifier without oversighting can violate fundamental rights. The second case is Glass v Germany. It was published in 1978. The case set the precedent that surveillance measures must be strictly necessary and legally prescribed to be justified under Article 8. It also required that oversighting mechanisms to prevent abuse by law enforcement agencies. And there are two types of legal framework. The first one is GDPR, General Data Protection Regulation. So it is introduced in 2018, and it reinforces that concept that individuals have ownership over their personal data. It also includes protection against unlawful police searches and seizures. The second framework is EU Charter of Fundamental Rights. So I think that Article 7 of the Charter of Fundamental Rights of the European Union mirrors Article 8 of ECHR, and also it explicitly guaranteeing that the respect for privacy and data protection. Like to conclude this question, I think that EU takes a highly protective approach to privacy, requiring judicial oversight and strict legal justification for police searches of digital data. So I think like unauthorizing searches can result in human rights violation under these two frameworks like ECHR and GDPR. Yeah. So moving to the next part of the assignment, like the next slide. What are the reasonable expectation of privacy in the states? So, like in the states, the concept of the reasonable exception of privacy, it is protected under the Fourth Amendment of the US Constitution, which states that, in the quote, the right of the people to be secure in their persons, houses, papers, and facts against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause. So, this states has been interpreted by the U.S. Supreme Court to mean that individuals have the reasonable exception of privacy in the places where there are two key points. The first one is they subjectively expect privacy. Second one is society generally recognizes that expectations as reasonable. So there are some key case laws. So moving to these slides, what are the landmark US privacy cases? So there are over three. So the first one is Cats v United States. It is published in 1967. So the Supreme Court ruled that the Fourth Amendment not only protect peoples but also places. Uh, a person has a reasonable expectation of privacy, like in a phone booth, even though it is a public space. But this case mainly established the cat's test, which courts uses to determine whether if privacy rights apply or not. The second one is Smith v. Maryland. It is published in 1979. It was created by the third party doctrine, not only limiting privacy expectation for the information, but also it was shared with businesses. The third one is Carpenter v. United States. It is published in 2018. The court ruled that the police must obtain a warrant before accessing cell phone location data. This decision significantly expanded digital privacy rights in the US, in the states. So, what are the legal limitations? So, the third party doctrine uh, holds that the people lose privacy expectations over information shared with the third parties, like internet service providers shared with the phone companies or with the telecommunication organization. The border search exception allows authorities to search digital services devices at airports and borders without a warrant. To conclude that the US has a robust but evolving legal frameworks that mainly works on privacy. Court also recognizes that strong privacy rights in homes and digital communications, but it lacks exceptions like the third party doctrine. This limits their protections. So moving to the fourth question of the assignment, when does the Canadian government, known as Crown, need a search warrant to seize a suspect's computer? So in Canada, Section 8 of the Canadian Charter of Rights and Freedoms, it guarantees that everyone has the right to be secure against unreasonable search and seizure, which means that a police generally needs a warrant before accessing someone's digital devices until under some circumstances exist. So when is a search warrant required? So it is required when there are three types, there are three main aspects. The first one is like the suspect had the reasonable expectations of privacy in the device. The second one is evidence is not at all risk of immediate destruction. The third one is the police have still a time to obtain a warrant without jeopardizing public safety. So there are some permitted warrantless searches and disallowed warrantless searches. So talking about the first one, permitted. So by R.V. Fearon, it says that it allows a limited cell phone searches incident to arrest without a warrant. It also says that it must be brief and directly related to the arrest. The second one is by R.V. Kasleke. It's in 1998, and it says that allows searches of personal belongings incident to arrest. So moving like talking about the disallowed warrantless searches, the first one is RV view. So talking about the RV view, the police must obtain a specific warrant to search computer and digital devices, even if they have already a general search warrant. Also, by RV Cole, it says that even when a work laptop was owned by the employer, and if the court ruled that employee had a reasonable expectation of privacy, it still requires a warrant for police searches. So, to conclude this question, the Supreme Court of Canada has ruled that digital devices contain very high personal information. It also requires strong privacy protections, but it is limited warrantless searches if they are allowed. Courts are very cautious, cautious about broad police powers over these computers. So moving to the fifth question, explain the concept of existing circumstances under a Canadian law. What circumstances might arise in respect to computer data and digital forensics. So, understanding existing circumstances in Canadian law, in Canada. Existing circumstances refer to urgent situations where law enforcement may conduct a search or seizure without a warrant due to an immediate threat to a public safety, property, or the preservance of evidence. So, like the Criminal Code of Canada under Section 487.11, it allows that a police to conduct searches without a warrant when there is a risk of imminent harm to individuals. The second one is evidence could be lost, altered, or destroyed before obtaining a warrant. The third one is also like delaying the search would jeopardize a criminal investigation. So talking about the digital forensics accident circumstances, so with respect to computer data and digital forensics, accident circumstances might arise in the following situations. There are over three, like risk of evidence destruction. The second one is live cyber attacks. The third one is immediate threats to public safety. So talking about the first one, if a suspect is suspected of remotely deleting data or using encryption to permanently erase files, police may justify a warrantless search. Also for the second one, like if an ongoing cybercrime, for instance, hacking or a ransomware attack, it threatens that critical infrastructure, it also might intervene immediately to prevent further damage. So the third one is like if a suspect's computer contains sensitive information that is related to terrorism, child exploitation, or even like threat to individuals, police may seize the device without a warrant and arrest the suspect immediately. So there are some key legal cases R.V. McDonald, and the second one is R.V. Patterson. The first one is like a police conducted a warrantless entry into home due to immediate safety concerns. It ruled like the Supreme Court ruled that existing circumstances justified the search, but it also emphasized that the police must act proportionally. The second legal case that the court ruled that the police can't rely on existent circumstances, but when they themselves create the urgency. Like a warrantless entry may be violated under the section 8 of the charter, something like that. There are some limitations on the existing circumstances, like police police action, like cops action, must be reasonable and be proportional. The court also examines that the was the risk of evidence loss real and imminent. Second one is like, could police have obtained a tally warrant quickly? The third one is like, was the search of warrant was the search limited to what was necessary? So to conclude that, it also allowed limited warrantless searches. The court scrutinized police actions to prevent abuse of power. Like in digital forensics, authorities must just show that the waiting for a warrant would result in irreparable data loss or immediate anger. So moving to the sixth question. So moving to the sixth question, what are the handling privileged information in forensic investigation? So what we discussed about earlier, like privileged information refers to the confidential legal, medical, or personal communications that are protected from disclosure. The most common form is a solicitor-client privilege, which protects communication between a lawyer and their client. In Canada, court ruled that searching privileged information without safeguards violates Section 8 of the Charter. There are some steps for a computer forensic investigator. If a forensic investigator encounters privileged information, they must take procedural steps to ensure that the information is not improperly accessed or used. Like there are four of them. The first one is immediate identification and segregation. The investigator must immediately stop viewing the document. The the privileged files must be flagged and isolated to prevent unauthorized access. The second one is the file should be sealed and encrypted until a court can review them. The second one is notify a neutral third party, also like we can say ident like independent review officer or special master. So like a law enforcement should be should appoint an independent reviewer. It is often a judge or a neutral legal expert, but it has access whether the documents are truly privileged. This totally prevents bias or misuse of privileged data by investigators. The third one is apply for a judicial review. If the crown believes that the information isn't privileged, they must apply for a judicial ruling before using it an investigation. So the defense may challenge the search in court, leading to evidence suppression if the privilege was violated. The fourth one is respect the privilege stream. So, or a Chinese wall approach. So, like some cases require a privileged team, uh, independent legal experts to review data before handling it to investigators. This not only ensures the law enforcement officer, but they do not access protected communication. So, like there are some legal cases. The first one is about Lavelle, Raquel, and Hans v. Canada. The Supreme Court ruled in that searching a law firm's office requires strict safeguards to protect privileged legal documents. The second case says like a forensic investigator um, found that it privileged emails on a seized computers. The court excludes the evidence, ruling that law enforcement should be failed to take proper safeguards to protect privilege. So to conclude with that, like handling privileged information in forensic investigations requires extreme caution. Investigators must immediately halt analysis, notify legal authorities, and follow strict procedures to ensure compliance with Canadian privacy and legal privilege laws. So, moving to the next part of the so talking about this slide, so what are the consequences of mishandling privileged information? Like as we discussed in the last slide about charter violations, professional sanctions, evidence suppression, and also about the cases like Lavelle and Thompson. So moving to the next slide about talking about the seventh question, what are the AMLETs? So AMLET stands for Mutual Legal Assistance Treaty. It is it is an international agreement between two or more countries to assist each other in legal matters such as criminal investigations, gathering evidence, and executing judicial processes. These treaties are designed to facilitate cross-border operation uh, between law enforcement agencies, and also it ensures that criminal investigation can proceed without violating the sovereignty of other states. But the treaty covers areas such as evidence exchanges, witness testimony, and even extradition in some cases. So, what are the applications in digital forensics and especially in AMLAT? So, given the rise of cyber crimes, terrorism, and cross-border criminal activities, they are essential for coordinating legal processes between countries. So, countries often need some assistance from foreign jurisdiction to not only collect evidence, but it may be located outside their own borders. Without a AMLET, a country can't request or provide assistance without violating national laws, as collecting evidence across borders without a proper legal framework. AMLETs also serves as a safeguard to ensure that uh, to ensure that the cross-border law enforcement actions are carried according to the law, respecting both countries' privacy and human rights protections. There are some how, why, and why AMLET might be used. So it typically requires a formal request for assistance, which is processed to government channels such as the Department of Duties in the US or the Minister of Justice in Canada. It are like amulets are also necessary because many criminal activities such as cybercrime it involves perpetrators who operate in multiple jurisdictions, making it difficult to prosecute them without cross-border legal assistance. They are also used in cases like in international criminal investigations, especially in cross-border crimes like cyber, child exploitation, drug trafficking, terrorism, and also like money laundering. That's it. So moving to the next question. So moving to the eighth question, three privacy principles used elsewhere in Canada but not part in Canada's framework. So the first one is right to be forgotten. It is in European Union in like general data protection regulation. So what is right to be forgotten? Like it allows individuals that to request the deletion of their personal data from the internet and databases, like particularly when it is no longer relevant or when the consent is withdrawn. So like utility like this principle is essential for protecting individuals' reputation and privacy online, preventing the data retention for negatively affecting one's life. It also allows individuals to regain control over their data in a world where digital footprints can often be permanent. There are some challenges it limits freedom of speech and it also public access to information. The second one is data localization. It is basically in Russia, China, and India. like countries like Russia, China, and India, it requires that citizens' personal data be stored within national borders. This ensures that the government should have greater control over the safety and security of data. It also reduces the forensic and foreign surveillance or data theft. So the third one is purpose limitation. It basically is in European Union and Brazil. So the purpose limitation restricts the use of personal data not only for purposes which it was originally collected. The principle ensures that the personal information isn't misused or repurposed for activities unrelated to the original content. The activity is like the principle lets like helps to protect individuals' privacy rights, but it also has challenges like in industries that requires flexibility to repurpose data for research or statistically purposes. So moving to the next question, what is the difference between privacy and security, and why is which is harder to maintain? So, like the terms privacy and security are often used as interchangeably, but they represent different concepts in the realm of personal data protection. The privacy, so it refers to an individual's right to control their personal information. It also encompasses the ability to determine who can access, who can collect or share one's personal data and under what circumstances. Privacy is also about freedom of personal autonomy, where the individual has control over what is disclosed to others. Security, on the other hand, refers to the protection of data from unauthorized access, alteration, or destruction. It is also about implementing measures like technologies that ensure the CIA of data. It also involves technical solutions such as firewalls, encryption, and secure access protocols that prevents malicious actors from breaching systems and accessing data. While privacy and security uh, are interrelated, but they are not the same. Privacy is more concerned with how information is used and shared, while security is concerned with information that information is safe from unauthorized access or loss. I think like privacy is harder to maintain than security for several reasons. First one is like complexity of consent. Second one would be data retention, and third one would be like there are some advances in technological part. So, like in contrast, security can be relatively easier to maintain, but it relies more on technical solutions. While this can be challenging and once implemented, they provide a stronger level of protection from unauthorized access. However, like the consent of evolution of cyber threats currently going in the current scenario, it maintains that security practices needs to be continually updated, and even the bad security measures can be vulnerable to new exploits. So moving to the next part. So, so talking about the last question, what is the PIS? So a PI is a privacy impact assessment. It is a risk management tool used by an organization to not only identify but also to access the privacy tool risk associated with the projects, systems, technologies, or services that involves collections. Like PIs are also like designed to ensure that the privacy concerns are addressed before implementing any new initiative that could potentially harm individuals' privacy. So PI should be conducted at the planning stage. It also has some significant changes and are made like and when data protection laws. PI may uncover when a privacy risk, legal non-compliances, and recommendation and the impact of the project. Yes, like in Canada, PIs are legally required under the Privacy Act and the PIPEDA for federal government agencies and organizations in certain sectors. The Treasury Board Secretariat's policy on privacy protection requires that PI must be performed for all new federal government initiatives involving personal data. So, to conclude very quickly, so moving to the slide, like to conclude very quickly, like I explored various aspects of law and ethics in forensic investigation. I also focused on the admissibility of evidence, privacy rights, and the legal frameworks governing not only the digital forensic in Canada and but also in the states and in the EU. The first few questions examine how illegally obtained devices evidence is handled in the court both in US and Canada. In like The concept of reasonable expectation of privacy was another key theme, particularly in the context of digital data. In in Canada, courts have ruled that individuals have a strong expectation of privacy in their personal devices, even in their workplace. This differences illustrate how privacy laws vary across jurisdictions, with the EU taking a more protective compared to the US. Finally, we discussed the importance about PIS, mutual legal assistance treaties, MLAs, and the challenges of the maintaining privacy versus security. So PIs are very crucial for identifying and mitigating privacy risks in new projects where breaches can have serious consequences. Overall, like this assignment underscores the complexity of balancing privacy, security, and law enforcement, a need in an era where digital data plays a central role in both personal lives and criminal investigation. So that's it of my presentation, Professor. Thank you so much. I hope like I'll hear a positive feedback from you. Thank you.